Good morning, everybody, and welcome to the International Conference Criminal Justice Child Friendly. This conference was organized under the project Child Friendly Justice, developing the concept of social court practices. My name is Antinente Bartolo, the project manager of the project. The project manager of the project from Prism Impresa Sociale. This event is the second of a series of conferences that were organized under this project with the aim to improve access to justice for unaccompanied children, focusing on the individual assessment process in criminal proceedings. It has also the purpose to raise awareness on how to benefit from the existing regulations, judicial approaches and practices, and how to transpose them into different contexts, such as Italy, Bulgaria, and Romania. There will be a broad international participation of about 15 legal and social professionals, such as lawyers, social workers, representatives of human rights organizations, institutions, local NGOs, and many others that we would like to really thank for the cooperation. During this conference, it will be given a constructive point of view to create a child-friendly courts around Europe, where human rights are effectively guaranteed, starting from sharing the presentation, sharing the knowledge of the professional that will be intervening during this 2 days conference. But it will be also provided a virtual space for participants from many European countries to provide feedbacks, to exchange opinions, and to exchange thoughts, or to give recommendations. The conference, as already anticipated before, was organized by Prisma Impresa Sociale with the kind collaboration of the project partners, Validity Foundation, Bulgarian Center for Non-Profit Law, and Center for Legal Resources. Just briefly now, let me give the floor to Alessandro Melillo, the chairman of the board at Prisma Impresa Sociale.
Good morning, Antina. Thank you. Thanks a lot. Just a few words from my side before leaving the floor to the panelists that I really thank for their kindness in joining the conference. As my colleague Antina said, I'm Alessandro Melillo. I'm the chairman of PRISM. PRISM is a social enterprise based in Sicily. We work mainly in Palermo, but our headquarters is based in Enna. I'm extremely happy on behalf of PRISM team to start this very interesting conference. For PRISM, this is, let's say, a crucial step in our growth because we strongly believe above all in this project, and I really thank all of the partners for the kind cooperation in the organization of this conference. And we strongly believe in the topic of this conference. It's not the first time that we as PRISM, we work in international projects dealing with human rights and with the rights of children. So the CFJ project for us, it's a very important step in the pathway we are building in this area. And we believe that after the pandemic, the world will face new challenges, and the topic of human rights, the topic of integration, and the topic of justice will be more and more important and delicate. So that's why in PRISM we are investing a lot in developing this strategy of working internationally in this topic. That's why we are involving new professionals with the, let's say, with the right skills and right competences in the field. And and we will continue developing international projects in this field. I just want to thank once again the staff of PRISM and the staff of the other partners of the project that are really supporting us in this conference. I want to thank once again the panelists. I'm really proud of such a high-level panelists in this conference, and I just want to wish a very nice and fruitful conference. And I really hope to meet you all soon, this time in person. So thank you once again, and enjoy the conference. Thank you very much.
Thank you, Alessandro. And actually, just connecting the proceeding of my intervention to what you just said. This conference was supposed to happen in person at the beginning, but due to COVID pandemic, we actually then proposed an alternative for having an online session. And also we have to say the positive side, the advantage of the online session, just to gather even more people from many countries. Hopefully next time will be possible. It will be possible to do it in person. Would be actually a great opportunity. Just to better understand the project context where the conference was developed, and just to have an idea about the frame within the conference is actually being organized. We would like to give the floor to Mr. Bruno Monteiro, the project manager from Validity Foundation. That is the leading organization of this project based in Hungary. So welcome, Bruno.
Hi, Antinea. Thank you for the kind invitation. Can't seem to turn on my camera. There you go. So it's a pleasure to be here, and thank you so much for the kind introduction. As Antinea mentioned, I'm Bruno Monteiro, and I'm project manager on behalf of Validity Foundation. Validity Foundation is an international NGO, a legal advocacy organization, which seeks to tackle the generation of isolation, segregation, and exclusion faced by people with mental disabilities in Central, Eastern Europe, and in Africa. This includes any form of exclusion in criminal proceedings. It's within this context that the Child-Friendly Justice Project arose, especially from the need to better understand how to ensure access to justice for children involved in criminal proceedings. This is specifically the case for children found in vulnerable situations, such as children without parents, migrant children, and children with intellectual or psychosocial disabilities. EU legislation emphasizes the need for criminal justice professionals to perform what's called an individual assessment to understand the situation of children who become involved in criminal proceedings. This is to avoid two common scenarios where, for example, in criminal hearings, a judge is unaware of a child's intellectual disability and communicates with the same child inappropriately, or other scenario where prosecutor makes support decisions about an unaccompanied child or child living in an institution without being aware of a conflict of interest that exists between the child and the legal guardian, for example. The means to understand the situation of the child is through individual assessments, where the information required to understand the child's situation is collected by trained professionals in a child-friendly manner that enables their participation and protection. So in this conference, you will have a chance, among others, to learn more what is the current situation in Italy and two other countries, in Bulgaria and Romania, and what measures have been proposed to make sure criminal proceedings become more child-friendly and sensitive to the specific vulnerable situation of the child. You can read more about the project on the project's webpage, which I'll copy to the chat box. And on that note, thank you for listening, and I really hope you enjoyed this conference. Thank you again, Antina, for the invitation. I think you're muted, Antina.
Sorry. Thank you, Bruno, for your brief but really intense intervention. We really appreciate our collaboration, our even further projects that we already we are managing together, and all the activities that are actually under planification. It's really great to have such an international team that is really keen on really making an impactful action. And really thanks to even all the other members of your team that probably are listening us today. So this conference will last 12 days, so we are going to be together, we hope, with all of you, or even with more, for today and for tomorrow. So during the morning time from 9:30 to 1:30 Central European time. And we would like to actually share, for those who haven't seen yet, the final agenda of the conference. Briefly would like to share it with you. So, as you can see today, we'll see in a while. We'll watch together a short video, just because we really were willing to have an impactful beginning of the conference. And today we'll have two sessions, and we'll introduce a specific topic of the session just before they will start. While tomorrow we'll have again, after each session, actually there will be 15 minutes of Q&A, a moment where all the participants can actually raise their hands and ask for a question or ask for a clarification. So feel free to intervene whenever you want, just raising the hand. And then there will be around 11:15 a break time, and by 1 today, the main intervention from the panelists will be probably over, and there will be space for, as we were saying, this conference wants to be also an opportunity for exchanging thoughts, actions, feedback, and to be really more interactive rather than constructive, and rather than providing specific topic oriented to the child-friendly justice. Tomorrow we'll also have, we'll start again at 9:30, and we'll also have two sessions. After the session as today, we'll have the opportunity to ask for question and clarification, always following the same rule as today. And by 1:30 tomorrow will unfortunately end up. So let's go into details about the specific topics of each session. For today, as we were already anticipating, we'll be more focusing on raising awareness about the applicable international standards, moving to relevant national reforms and or the promising practices and real-life experiences through the voices of the children of migration and the professionals working with them. Learning from the experience helps, from our point of view, to improve the individual assessment procedures in a pre-trial and trial phase for a more child-friendly and inclusive justice. Before giving the floor to our panelists, we think that it's pretty important to provide to our audience some general information, especially about our target group, about what we mean with unaccompanied migrant children. Unaccompanied migrant children is the actually the way we prefer to mention the target group we are dealing with, just because using the expression from our point, it's a more neutral and inclusive name instead of minors. That kind of implies reductive interpretation. So just to be clear, just to be everybody on the same page, we would like to clarify that what we mean with unaccompanied migrant children, according to the Article 2 of the Directive number 86 of 2003, are the third country nationals or stateless persons below age of 18 who arrive on the territory of the member states unaccompanied by an adult responsible for them, whether by law or custom, and for as long as they are not effectively taken into the care of such a person. So just when we talk about, during this conference, about unaccompanied migrant children, have in mind what we mean with that. Finally, in terms of principles that are applicable to criminal proceedings, and in terms of what we are really having in mind, taking into consideration while implementing this project, we think that it does exist. There is a mutual connection between the child best interest and the individual assessment, as the individual assessment seems to be a condition sine qua non to ensure substantially equal children protection from a multidisciplinary point of view. We'll talk a lot about what we mean with multidisciplinarity, and we'll actually listen also some successful example of multidisciplinary approach. So that's mainly that's going to be mainly the concern for today's session, and actually even further than today's session, because our purpose is even to provide you some tools, some knowledge to be used even further in your professional environments or even personal lives. And now we'll proceed actually to the testimony part. We'll show you shortly a video that actually tells the story of a child. This story that you are going to listen is based on a real life experience of an unaccompanied child whose name has been changed into Amin for privacy reasons. The story was collected under the project in the first phase, during the interview phase. We would like to thank Ahmed Isaac Hussein, who is giving voice to the story. Is not the unaccompanied child that is actually telling the story, but is also giving voice to it. He's a cultural mediator of Somalian origin, who arrived in Italy when he was actually under then 18, and was collaborating with PRISM for years right now. So enjoy it.
I'm Amin, and I left my country of origin in 2017 when I was 16 years old. I left my country because I had a lot of family problems and I didn't have access to education. So I decided to start a new life in this country. When I arrived, I didn't understand the language, the culture, the habits, and nothing. I was so stressed. But the reception center where I was at were helping me with social and legal assistance. They also encouraged me to go to school. It was so stressful situation for me because I felt so lonely. One day, I received a bad news that my uncle died. He was like a father to me, and I was so sad and so shocked. At that same day, a social worker from the reception center asked me to do something that I wasn't supposed to do and I didn't want to do. I tried to explain to her the reason why I did not want to do, but she kept insisting it until I got so angry and I started shouting at her. And I also broke the door. She got so offended and she decided to report me to the police. I was then arrested. I was so scared because I never thought that she would report me to the police for what I've done. During the proceeding, I was had by a police officer. Then I was had by the judge 2 times, where I was given the possibility to express myself. And at the time, I was so scared and I didn't know what was happening. But thanks to the using social workers, they helped me a lot. They were explaining me everything step by step, and they were motivating me a lot. And I had to trust them because I didn't have anybody else. At the end, the proceeding concluded in 1 year probation. But I can say that I was lucky enough because I understood the Italian language enough. I could defend myself, and I also had the using social workers on my side. But not everyone is lucky enough. And my recommendation for the Italian justice system is that they should listen to the minor's point of view, and they should also provide us with cultural mediators and social workers who understand us. Because most of the time it's not easy, especially when you're new in a new country, when you don't know the rules and the regulations. And it was a frightening situation. And today I can say that I have my own life because I work in a restaurant, I have my own friends, and I'm hoping to live in this country for the rest of my life.
So this is the story of Amin, and we hope that you enjoyed it. It gets quite emotional actually when listening at Ahmed, because he's really feeling what he's telling, even although it's not its personal story. So we also would like to officially thank Ahmed for the interpretation that he has given to this real story. And for this purpose, we also would like to give our thanks to all the professionals. And actually, during these 2 days, we'll have many of them that are contributing to protect children's rights, to effectively protect children's rights, doing their job as they should. So now we are ready to, after getting this really emotional beginning, we are ready to start with session 1. And for this purpose, during session 1, we'll have 2 panelists. First panelist is going to be Alessia Cassia, that is the IOM project assistant from International Organization for Migration, and we would like to take this opportunity to give our thanks to the job that actually IOM, even together with other local actors, whose contribution was really really important. IOM as an international organization, as a UN migration agency, for the contribution that they brought against the phenomenon of human trafficking, either at local and at international level. So it's time now for Alessia Cassia to proceed with her intervention. Thank you.
Grazie Antinea. Buongiorno a tutti.
Thank you, Atenea. Good morning, everyone. I try to share my slides. Antinea, can you please confirm that you can see my slides? Can you see them? Yes, perfect. So, good morning, everyone. Alessia Cassio. So as Anthea said, I'm a project assistant for the International Organization for Migration. Today, I thank the organizers for inviting me and all the participants. Today, I will focus on human trafficking. As you can see from my slides, I will talk about the reference standards with some references to the national regulations and the systems of protection for the victims of human trafficking in Italy. And I will focus on the human on the trafficking of human beings and what has been developed on the basis of arrivals from the sea, especially of Nigerian women. And I will talk about the role of the International Organization for Migration with references to early identification of victims of trafficking from the sea and also of our context. So I will talk about mixed flows. In the last few years, there were several changes concerning flows from the sea in terms of figures. There were sometimes a high number of migrants disembarking on the Italian coasts, but from 2019, the figures have decreased as compared to the past. Today, arrivals are still there, but they cannot be compared to the figures of 2007, for example, when there was a high concentration of migrants disembarking on our coasts. The changes concern other elements, among which the nationalities. We pass from periods in which Eritrea and Nigeria were the predominant nationalities for people coming from the sea, two periods in which main nationalities were Cote d'Ivoire and Tunisia. And this is strictly linked to the opening or closing of the routes from Libya. From Libya, there are less people who leave. This is due to the tragic socio-political situation linked to the reference country. And this is the route from which women victims of trafficking leave. Nigerian women destined to sexual exploitation in Europe. Concerning the route for Tunisia, recording a high number in people leaving from there, it is the route that is mainly used for traffickers, for transportation, because victims of trafficking of Cote d'Ivoire nationality can reach Europe to be exploited in sexual contexts and destined to forced marriages. But regardless of the reasons why these people leave the country of origin, people who arrive in Italy are people with the vulnerable typologies. There are unaccompanied children, women, most of them are pregnant due to the violences especially in the transit countries, people with mental disorders or disabilities, single parent groups, elders, victims of torture, violence, genital mutilation, and of trafficking. Concerning the last vulnerability, and I would like to focus on this, this is Article 601 of the Criminal Code, Chapter 1, in order to understand the elements of the crime. So, those who recruit, introduce, transport, or gives the power on the person, or receives one or more people, can be punished with prison from 8 to 20 years. And this concerns those who are in the conditions under Article 600. And so this concerns the various methods by means of the threat, use of force, other forms of coercion, of abduction, fraud, deception, abuse of power, vulnerability. And in this slide, I have summarized these elements. So the standard refers recruitment, introduction in the territory, transfer from the country of origin, transport, the cession of power and hospitality, and coercive methods. We find the fraud, the violence, deception and threat, abuse of authority, and exploitation of a vulnerability situation, promise or offer of money. There are many situations of exploitation: work, sexual, begging, illicit activities. Many victims of trafficking are obliged to carry out illicit activities and the removal of organs. Concerning the victims of trafficking who decided to emerge from their situation of exploitation, the protection instrument is Article 18 of the Legislative Decree 286 of 1998. It is an innovative instrument because there is a double path. The victim who decides to emerge from an exploitation situation can decide to follow a judicial proceeding, and so to lodge a complaint against the traffickers, and can use this type of instrument and obtain a residence permit, even if the complaint is not formalized. But in these cases, the victim must adhere to the assistance program of social integration, must accept the commitments and the program related to the reference facility in which he or she will be included. I introduced this slide because in many contexts there is a confusion between the trafficking and the smuggling. As you can see, I included the common elements of both the crimes and the differences. In trafficking crime, there is no consent from the victim. If we refer to adults, the behavior is through coercion methods, the consent is not relevant. In the case of foreign unaccompanied minors, the consent is always irrelevant. The consent of the victim, the crime of trafficking is internal, it's not necessary to have an irregular entry in another country. But the smuggling crime envisages irregular crossing of borders. The relationship between victim and the exploiter in the trafficking crime implies the exploitation of the victim. In the case of smuggling, the relationship implies irregular crossing of borders only. In the case of trafficking, the profit comes from the victim exploitation. In the case of smuggling, the profit comes from the payment of the service offered to the reference person. Trafficking is a crime against individuals. Smuggling is a crime against the state. As to the elements that are common to both the crimes, they involve criminal groups well organized and rooted in the reference countries, country of origin, country of transit, and in some cases, country of destination. And there are businesses that involve human beings. Some figures on the victims of trafficking from the sea from 2014 to today. In 2016, there was a boom of arrival of women from Nigeria. More than 11,000 women arrived. The figures are very important concerning 2015 and 2017 too. So where are all these people now, all these potential trafficking victims arrived in the last few years? These people are still in Europe. In many cases, they are still exploited. And in the last period, we see some arrivals from other countries of the European Union where victims were exploited for many years. So we start with them a rehabilitation path. They are entered, they are admitted into a rehabilitation facility. Just to give you a few concrete examples, we have identified many victim trafficking for begging. They entered the Italian territory as children, but they are 20 years old now, and we are referring to men in this case. So they come from other European countries, and so it is very important to keep identifying in an early manner the victims, because they are among us and they must receive a support allowing them to have the right tools to emerge from the exploitation situation in which they live. And let's see the trafficking indicators at the borders of Nigerian women over the years concerning the arrivals of women shown in the previous slide. Most women are Nigerian, and they were between 14 and 23 years old. So when they arrived, when we met them after disembarking, many women during the identification phase by the authorities tended to say that they were um, they were of a majority age. So this is an important aspect because many traffickers tell victims that they have to say they have a majority age because it is simpler for traffickers to have a woman escape from a facility structure rather than a minor woman in a more protected facility. So they are forced to declare their age. Concerning the aspects concerning the attitude of victims when they arrived, very often they move in groups, they are silent, they ask a confirmation, they ask a person of the group for confirmation, just even to move and to talk, so we can immediately see a submissive attitude. And so it is important to be focused on the group. We have to organize individual interviews with people. Very often, these women say that they are sisters, 3 or 4, and so they have to be transferred together. But in this case, it is very important to organize individual interviews because very rarely there are sisters who arrive together. So it is very important to have individual interviews and to match the information. In most cases, we see that it is very difficult to match this information because the information is different, but it is clear that they are not relatives. And this is very important. Why? In those cases, it is important to divide them because even if these are two little girls who are friends, if they are destined to the same trafficker in Italy or in Europe, we remove the possibility of emerging from the situation because she might be influenced by the other victim. But in other cases, some women say that they are uncles or mothers of these girls. And so in this case, too, it is important to organize individual interviews because these are at-risk cases. They might be potential victims of traffickers traveling on the same boat. They would like to be transferred in the same reception facility, but the trafficker might control the victim. And so the boy or the girl would have no possibility of emerging from the situation. Concerning the profiles, most girls or boys were eldest daughters of families with problems of poverty, low level of education, but there are also some girls who studied in their country of origin, but they did not have the possibility of continuing their education. They accepted these educations and they accepted to live and to leave the family in order to ensure a better future for themselves and for their family of origin. These girls are dreamers, like all girls of this age. They hope that the trafficker is not the person who will lead them to a condition of total submissive condition. So they hope that they are the good person. And very often these girls say that they didn't pay anything for traveling, they don't know the various parts of the travel, so it is evident that there is something wrong. Concerning the recruitment area, the most significant recruitment area, we know that this area was Edo State from Nigeria. So in order to arrive in Niger and then in Sicily, not all girls coming from that state or from other states of Nigeria, these girls were brought to Benin City for the voodoo ritual. We will talk later about this. Concerning the trafficking indicators, I don't know whether there are some receipt workers. I see that I have not a lot of time available. Anyway, so these girls who arrive at the received facility with some rules, entry and exit rules, they are suspicious, that they are aggressive vis-a-vis the people around them. They excessively use the phone, and they are controlled by the criminal networks. And so they need to start sending money to the reference people. And so they are obliged to prostitute themselves outside the receipt facilities. So when they arrive at the receipt facility, it is important to identify their behaviors, check the calls and the calls made to the family of origin, because this is the first moment when girls leave the receipt facilities, and then they follow the criminal networks. So there are some limits to the identification, control by traffickers, a fear of voodoo violation. There is a distrust vis-a-vis authorities because they well remember the reference system of the country of origin. Quite often they don't trust this system. In many cases, many cases they have a false information from traffickers. They are told that if they want to emerge, if they want to talk about their situation, they would be brought back to Nigeria by the local authorities. And quite often they are not aware of the condition of victim in which they are. And so they have a sort of a gratitude towards the person because they reached Europe. And concerning the interview, that is fundamental in order that the victim can have the right tools to emerge from this exploitation situation. When the victim decides to talk about her situation, once the positive elements of the crime have been identified, it is important to report the victim to the National Anti-Trafficking Network, and this report will be sent to the competent authority of the network. If the victim decides to enter a rehabilitation path, the victim will be admitted to a secret facility. If the result is negative, anyway, the victim must have the right tools to have the possibility to emerge from this situation later on. So it is important that all the victims know this free number, so they can contact the worker and the reference victim. I only have 3 minutes, so I think that it is important to keep talking with other slides and to tell you about what the organization is doing.
In riferimento a questa tipologia di attività, comunque garantisce supporto alle potenziali vittime, come vi dicevo prima, anche quelle che fanno rientro da altri paesi, in altri contesti. Quindi sono attualmente attivi progetti SAS e Sirio. Attualmente abbiamo circa 280 mediatori culturali che sono dislocati in tutta Italia a supporto delle attività degli uffici immigrazione delle questure, quindi si trovano sia nelle aree di sbarco e di rintraccio, ma anche nelle frontiere aeroportuali, e in quei contesti, diciamo, riescono a supportare le vulnerabilità delle persone che si presentano magari in questura per il rinnovo del permesso di soggiorno, e quello può essere l'unico momento in cui la vittima può essere agganciata per molte situazioni in cui si trovano le vittime che magari sono completamente isolate dalla società che li circonda. In questi casi ovviamente il team OIM con i mediatori culturali, con il supporto di alcuni assistenti di progetto che sono in varie zone del territorio, riescono a fare questo referral delle vulnerabilità. Oltre a questi 2 progetti sono attualmente attivi altri 4 progetti dell'OIM, in riferimento ovviamente alla protezione, quindi alla identificazione di vulnerabilità.
Alessia, scusa, abbiamo un problema sull'interpretariato. We have a problem with the English translation, so we're gonna try to...
Sorry. Oh, okay, sorry, I was on the wrong channel. Can you hear me now? Can you hear me now? Can you hear me now? No, it's okay.
English language, and we'll try to...
Yes, it's okay. Can you hear me now? There was a problem with the changing over. Can you hear me now? No, it's okay. Yes, can you hear me now? It's okay. Can you hear me now?
Yeah.
Okay, we can start back. Sorry for this.
Okay, but I think I'm about to finish, so
Ok, possiamo ricominciare comunque anche in italiano, grazie.
Ok, gli ultimi progetti di cui...
So the last couple of projects I would like to talk about, I will mention them briefly. This is the one, as you can see on this map, Al Caporalato, Supreme, Diagrammi Nord and Diagrammi Sud. They cover the whole of Italy. So these projects, they try and fight work exploitation conditions. They try and identify vulnerable conditions concerning work exploitation by caporalato. We have also identified trafficking victims who are still victims after many, many years of work. They still have to pay back their debt for getting the money to migrate. So we are trying to fight all these activities, all these contexts. In all these areas, there is a high concentration of migrant workers, and mediators also also support national inspectors, labor inspectors. They collaborate in the various areas, trying to promote communication between migrant workers and the institutions. In other words, they need to bridge the gap between workers and institutions. I'm now going to finish with these open questions that should promote some discussion, some food for thought. Which are the reasons, in your opinion, for which we need to have an immediate approach to victims. So it's very important to have a very early identification of victims as early as possible, and also that we should get a better knowledge of this trafficking process. So to improve our knowledge of the trafficking process. Thank you. Thank you very much again.
Thank you, Alessia. Thank you for the presentation. You were really perfectly on time, and it was great to hear your presentation. Before proceeding, we would like to actually, just to be on the same page, we would like to ask participants if the interpretation is going well, like just for those who arrived a bit later, the interpretation can be changed in the bottom side of the Zoom application, and you can just switch to Italian or to English. Just you will see a kind of the word, the icon of the word, and you can switch it there. While the sign language interpretation will be right on the normally on the top of the page. And just for those who maybe haven't an updated version of the Zoom platform, it's good if you download actually the app, because from the browser it doesn't seem to work properly. There is a problem with the updated version of the Zoom from the browser. So just if someone has some troubles with the interpretation, just maybe let us know, and that's maybe the issue, what I just said. And just for anyone who would like to ask questions, we already received some questions in the chat, and actually, as we were anticipating at the beginning, the Q&A moment will be at the end of each session. So in about 30 minutes after the intervention of Ms. Carolina Babica, we will have space for questions. So if those who launch a question on the chat can be patient for one more intervention, would be great. And we'll also discuss based on the open question at the end of each presentation, even in that range of time. So now it's time for Carolina Babica, a human rights lawyer from the International Commission of Jurists, will make an intervention named International Legal Framework and Challenges of Individual Assessment of Children in Conflict with the Law, Preliminary Results of the Practice Project implemented in Czechia and Slovakia. Thank you, Carolina. Here you are. The floor is yours.
Thank you. Thank you so much, Antonia, for this introduction, and thank you to all organizers for inviting me to this conference. It's very interesting. Thank you also to Alessia for this presentation that I really followed with a great interest. So I'm very happy to be here. Let me just try to share the screen. Does that work? Can you see that?
Yes. Yes.
Perfect. Great. So I will actually step back a little bit and will not be as practical probably as my press speaker, and will still go back to really international legal framework, international human rights standards that kind of underpin this field of work. And in the same time, I will not be looking so much at victims, but rather on the other side, so to say, on children in conflict with the law, and especially on the individual assessment and the requirement for the individual assessment in the child justice process. I will be looking also at the challenges that we have so far identified with this process, and I'll be basing myself a lot on the preliminary results we have so far from the practice project that is currently being implemented in the Czech Republic and Slovakia. So maybe just to say very briefly something about the International Commission of Jurists. We're a global human rights organization with quite some history, founded already in the 1950s of the 20th century. And the ICJ is really looking for contributing to the interpretation and implementation of the human rights standards to be more progressive. And so we're really looking at a range of human rights issues across the world and across the regions. We have a number of regional programs. And I'm based in the Europe program of the ICJ. So it's interesting, especially for me, this project, because we've been working a lot also on migration, on the rights of migrants and refugees as one stream of work, but we're also looking at the rights of children, and especially children in child justice system and children in conflict with the law. And so this project somehow also merges these two areas, which is really interesting. So just to give you a bit of a background of what we're currently implementing by the Europe program in the EU, we're about to finalize this project called Practice, which is really looking at the individual assessment of children in conflict with the law, which is based in the Article 7 of the Directive 2016/800. And within this project for the last 2 years, we've done a baseline study. We did research in a couple of countries, in Belgium, in the Netherlands, in Finland, and in England and Wales, as well as in the Czech Republic and Slovakia. That's the kind of two main focus countries of this pilot project, where we then also did some national trainings for the practitioners that are involved with the individual assessment. These were mainly judges, lawyers, and social workers. And we're currently drafting recommendations on the main principles governing the individual assessment of children in conflict with the law. Just to also complement this perspective that we're having, especially in this region, we also have just recently received a decision in the collective complaint that we lodged ICJ with the support of Forum for Human Rights, our Czech and Slovak partner. And it was a collective complaint that concerned children in conflict with the law below the age of criminal responsibility. And I'll speak about this specific group in a bit later, but it was a very important decision by the European Committee on Social Rights. And the committee found a violation of Article 17 of the European Social Charter for lack of access to legal assistance and lack of access to diversions. So this is some kind of our background, but now really to move on to what is individual assessment. And as I said, we're basing ourselves on the most recent EU legislation on this, although this institute in itself is not entirely new. But so it is based in the Article 7 of the Directive on procedural safeguards for children who are suspects or accused in criminal proceedings. So what it is by the directive, it says that member states should ensure that the specific needs of children concerning protection or education or integration are taken into account. So usually, really practically speaking, the individual assessment would be in most countries a report by a social worker or by a specific body, where usually there's a contribution by a number of actors, and that's also this multidisciplinary element of the individual assessment. So it's not entirely set what exactly needs to be in the individual assessment. That always would depend on the circumstances of the case and of the child. But I think what's really important is the purpose, is what is actually the goal of the individual assessment, what it should actually serve for. And so when we look at Article 7.4 of the directive, it has really three main aspects, saying that the purpose is determining whether any specific measures to the benefit of the child are to be taken, assessing the appropriateness and effectiveness of any preliminary measures, and assisting in taking any decisions in criminal proceedings, including sentencing. So you can see here that actually most of the purpose is really linked to the proceedings themselves, that the individual assessment should really help the child in the proceedings so that the process is somehow reflecting the specific circumstances, the needs of the child, the specific vulnerabilities of the child. And sentencing is just one very last part of the purpose. But this was very interesting for us to see also in the research we did in Belgium, the Netherlands, or Finland. Basically, in most countries, the individual assessment is done, but mainly is being then taken into account for the sentencing. So it's not really there in practice to influence the proceedings, so to enable the child actually to have their right to be heard, really effectively participate, to have their best interests really taken into account. Usually it's only used for to inform the sentencing. That's usually the moment where it's really looked at. So that, I think, is already one kind of critical remark we would have on the practice, and there's a number of other challenges. So as I just mentioned as well, it's not an entirely new concept. Actually, already more than 100 years ago, when the child justice systems were coming into life, the aim was, it was already there. It was put into the legal framework. And the aim, at least in the Czech and Slovak context, but in many other countries as well, was to find the most suitable measure for the child and to contribute to the re-education of the child. So again, it was really looking at the impact on the sentencing, and it was not at all kind of grounded in this rights-based approach. So I think that's also something, and that's why we also put so much emphasis on the international legal framework, because that's really shifted during the last century, and especially with the UN Convention on the Rights of the Child and other standards that really have shifted now to child protection, away from child protection approaches, really that were more like patronizing, just doing things for the child from the adult's perspective, that we know what's good for the child, and the child would really be treated as an object in this protection approach, and moving towards like a rights-based approach where the children are seen as rights holders, and they are really those that can also make decisions about their lives given their level of maturity and access to information, and so on and so on. So that's, I think, the biggest shift we also want to show, because to some extent also the text of the directive, to some part, may be still also reflecting the old system, but as it has to be read also within the current international human rights framework, it's very clear that the shift has been made. So yeah, as I said, so the individual assessment for children is important because they're in a situation of vulnerability. They're entitled to procedural rights and safeguards, and especially because the judicial proceedings will have such a high impact on their life, it's really important to make sure it's being used. And if it's used well, then it can definitely increase the effective participation of the child. It can determine their best interests. That can actually also help to prevent discrimination, and yeah, further improve access also to the procedural rights of the children, especially when they have special needs or special vulnerabilities and so on. So moving on to the international legal framework, I mean, basically we have a list of international human rights standards that are all applicable to children, suspect or accused. And so based on that, you know, every child is entitled to a set of rights. So I think this is really the starting point that we need to take. Especially with procedural rights, I think it's really important, and that's why I will also speak a little bit more about the judgments, because traditionally adults would have access to procedural rights, access to their lawyer or access to information, and children were not having such set of rights because they were really still in this protection approach, so they wouldn't really be given access to the rights as rights holders. So definitely we need to look at the UN Convention on the Rights of the Child. I just really briefly mentioned, because I think, you know, most people in this conference are very familiar with this, but just not to omit anything important, we have very important guiding principles set out in the UN Convention on the Rights of the Child: the best interests of the child principle, right to participate and right to be heard, non-discrimination, and right to life, survival, and development. And so also in our work and in the recommendations for drafting now, we really try to use these and really apply them on when the individual assessment is practically being done. And then, yeah, in Article 40, we find more information on children in conflict with the law, while what I think is important to stress that really children should be treated in a manner consistent with the promotion of sense of dignity and worth. So let me just mention a bit more about children below the age of criminal responsibility, as that may be sometimes quite a difficult situation. These children may be forgotten a little bit. I can give an example in the Czech Republic, where children aged 15 to 18 take part in the juvenile justice process. They can be criminally liable. So there is a Juvenile Justice Act that applies to them and grants them a good level of procedural rights. But children below the age of 15 do actually not have any access to such procedural rights, while in the same time they still can be actually subjected to very formal proceedings. They can be interrogated for hours sometimes without access to a break, access to a parent, access to a lawyer or anyone else to support them. And in the same time, the measures imposed on these children, even they're not criminally liable, can still be quite harsh. And it can amount to deprivation of liberty as well in maybe a psychiatric institution or educational institution. So I just want to mention here two recent cases. One is Blokin versus Russia in front of the European Court for Human Rights. And one is the collective complaint I mentioned earlier, ICJ versus the Czech Republic, where in both cases this looked at children formally below the age of criminal responsibility, but both the committee and the court have really looked at the practical way of the proceedings, how they're ongoing, and what is the result, saying that the fact that these proceedings are classified as civil that is not decisive. It does not mean that these are not actually these are not similar to criminal proceedings. And so that's why also children that are below the age of criminal responsibility should even less so have weaker legal procedural protection than adults. So in both cases, it's an interesting ruling which really gives like power to access to procedural rights for these children. So there's a number of international instruments that speak about, especially about access to justice and access to procedural rights, especially child-friendly justice. Principles are all very much relevant here, especially for the individual assessment. There's also a special requirement for the proceedings to be conducted in a language that the child fully understands. So just to flag that, because that may sometimes even not be in line with EU law, which may sometimes in certain situations say it's a language which the child is reasonably suspected to understand, while international human rights standards are very clear on that it really has to be a language that the child fully understands. And that I think is quite relevant also to the topic of the conference. Then obviously we have a set of procedural rights and guarantees. The children have to have access to legal assistance and to legal aid as well, from ideally the earliest contacts with the justice system. They should have access to information, and that's quite important, because they also need to have really access on what is gathered on them throughout the individual assessment assessment for the report. I mean, the report, the individual assessment report is there to help the child, but it might not always be helping them in practice. And that's also why we're actually doing this project and why we're drafting these recommendations. So this would be one very important safeguard, that the child has access to what is being written about them in the report and be able to comment on it, which also would be stemming from international human rights law. But unfortunately, it's not always the case, and the child does not always know what is being said about them or cannot express any comments on it. And then the right to interpretation, just to stress as well that it should not be only for their contacts with the justice system, but also to be able to communicate with the lawyer or with the guardian. So individual assessment does not appear to a large extent in international human rights standards, but we still have a couple of mentions, such as in the Beijing rules, that say that the background and circumstances of the child, especially in which the child is living, must be considered. And like in this case, in this connection, I just need to also highlight that a lot of times there's a lot of problems already stemming from systemic discrimination and basically the environment in which the child finds themselves, the environment in which they're growing up, which can have sometimes negative impact on their lives. And the fact that this is considered in the individual assessment, it's important, but it also has to be used in a correct way and not to the detriment of the child, which again, sometimes unfortunately is the case. The Havana rules say that the child needs to be interviewed as soon as possible when they're detained, and they must be, reports must be prepared identifying any factors, looking at specific type and level of care and programs that are required. And the UN Committee on the Rights of the Child also encouraged the individual assessments of children in its General Comment number 24. Here, just to mention, obviously, a very important decision, DNV versus the UK in front of the European Court for Human Rights, which really spoke about the effective participation of children in the criminal trial and the need for developing some procedures of the individual assessment. So that also very much, the court very much acknowledged the need for that, as well as in Blokhin versus Russia. Under EU law, I've mentioned already the Directive 2016/800, which is kind of the crucial one and where the individual assessment is rooted. But it's also important to look at the EU Directive 2016/680, which is which kind of came together with this other directive as a package of procedural directives, and it's looking at processing of personal data within the criminal justice system. It's not only focused on children, but it's a very clear and very specific directive, and very clearly states for which reasons and purposes can still personal data be collected, and how they need to be processed, and how they can also be shared between subjects. And as well, it mentions the right to access to the data, unless there's very specific limitations that would apply. So that, I think, is again quite a basis for to challenge basically a lot of times the practice that I mentioned before, that data is not shared, the information is not shared with the children. And even more so, the data is also very often in practice shared without any boundaries. So it's really, there's this holistic approach or multidisciplinary approach that's always being highlighted by the institutions, but it also needs to be really done in a way respecting all these standards, because if that's not the case, it really violates a lot of these standards. So in practice, there may be a social worker just, receiving an information and sharing it very openly with all the other actors that are involved in the individual assessment process, while they're not actually supposed to. They might not need to share every single information with all the other actors. What is a very problematic practice as well is the lack of citation, lack of including specific sources for an information. So there's often one information that may come from the school, from one person in the school, which then the social worker would just put into their report without any citation of a source. So this information will appear already in the report from the school and then in the report from the social worker, as if these were two independently coming in information, but it's actually just a duplication of one information that may or may not be correct. And sometimes this information really can get multiplied. And so I think we also realized that a lot of times in the Czech Republic and Slovakia, there is a very high level of institutional trust, which may be sometimes higher than trust to the person themselves, trust in the child and what they're saying. But if there's something that comes from the school, the psychologist, the social worker, even if the source is actually not being verified, it will take precedence, it will take over and may actually distort the reality. So, I mean, I mentioned already a couple of the challenges throughout. So just to kind of sum it up, I mean, what we have at least been able to observe in the Czech Republic and in Slovakia, but I think to some extent, a lot of these elements appear also in a lot of other countries. So that's definitely the lack of participation of the child. So the child still is being objectified. The individual assessment is still being approached in this very old-fashioned manner, in this protective welfare approach towards the child. So even though the social worker may talk with the child, that doesn't mean that the child really participates. They use them as a source of information. They ask them a couple of questions, but that might not mean that they actually are really involved, that they can actually participate in the individual assessment, that they can actually raise their opinions, and especially that they can comment on the report. So as I mentioned already, there's really this uncritical institutional trust, and sometimes holistic approach might mean a lot of professionals speaking with each other, but not with the child. Then, we wouldn't think that's really the good practice. As I mentioned as well, the rules of exchange of information among professionals seem to be very unclear, and sources are not adequately cited. So that really leads to a multiplication of information, and child is not given access to the report. So that really is a problem. And I think probably the biggest issue we have seen is really stereotypization or some kind of discrimination based on the background of the child. So there's structural deficiencies that usually these children will be facing, such as social exclusion, poverty, or just inadequate access to resources, basically, which can then, in the report with already some kind of a prior bias, be used rather not in favor of the child, not as a right of the child and to help them in the proceedings, but rather to their detriment. So it may be kind of putting the child in a very stereotypical view. I mean, Roma is the biggest minority in the Czech Republic and Slovakia. So usually, this label of Roma from a family, parents don't work, child skipping school, or parents alcoholic, all these little points will be actually used just to kind of picture the child as someone who's problematic or who should be put in a educational center with deprivation of liberty and so on. So that's actually really worrying, that rather than using the child justice system as an opportunity for the child to really also be able to share their aspirations and their kind of ideas of what they want to do in life, and that kind of being taken into account in the process, and perhaps even helping the child to get on a right track, so to say, it's sometimes only adds to their already situation of discrimination in the country. So that's all from me. I just include some final questions as well. It's more also things that we're kind of thinking of when drafting the recommendations in this project, like how to actually make sure that the individual assessment will be carried out in a non-biased manner. Because, for instance, we had discussions about the lack of concrete methodology, but then we're also quite worried about, just solutions that are like tick box methodology. If you don't actually change the overall approach, it may not be really a solution. Then another question, obviously, how to make sure there is a participation of the child in the individual assessment, and how to make sure that really it has impact on the proceedings, and that these are adapted following the individual assessment. So thanks so much.
Thank you, Carolina. It was great to hear your presentation. So now, actually, as promised before, there is space for questions, clarifications. There were actually already some questions in the chat, but if someone else wants to ask something in detail, just feel free to raise your hand. I'll give the floor to my colleague Giuseppe, and we'll proceed to the Q&A moment. Thank you.
Thanks, Antinea, and thank you everyone for being here today with us in this first day of the conference. I'd like to say very quickly a huge thank to Alessia and Carolina for their work and for the very good presentations that you gave us. You gave us the chance to understand how different and how the same could be the work that it has to be done in terms of individual assessment when we speak of young children, victims, or suspect or accused person in a criminal proceeding. So we have now the session that it's a question and answers. So we already collected a couple of questions during your presentation. There is the first one that it's from Bruno, and it's for Alessia. And the question is, how can criminal justice professionals find out the age of the child for support when the child say they are adults? Alessia, perhaps you to reply to the question that Bruno asked you. I give you the floor.
Grazie mille. Provo un attimo a rispondere, anche se mi sentite?
Yeah.
Ok, perdonatemi, purtroppo c'è un fastidiosissimo rumore di sottofondo, ma...
Excuse me, there is a background noise, but I hope that you can hear me. Concerning age assessment, I think that Carolina answered in her very interesting presentation, and I thank Carolina for this. She talked about a holistic approach, multidisciplinary assessment of age that envisages the participation of many professionals, psychologists, anthropologists, who will conduct multidisciplinary examinations and will give a result concerning the age of the victim. And in the final report, there will be a margin of error concerning the age, of course. We are talking about the potential trafficking victims, and I refer to the victims, and I would like to stress this. I think that it is important to stress the fact that victims can be identified as victims even when exploitation has not occurred yet. It is important to prove the purpose. The purpose is exploitation. Thank you. Unfortunately, I have to leave. So thank you. I have other business commitments, and so thank you very much. I think there are no more questions for me. Is that right? Thank you. Thank you, Alessia.
Yes, Alessia, thank you very much for replying to the question that Bruno asked. And there is, I do recall that there was some other one asking the possibility to ask for a question. If there are no questions for Alessia, we can just move to other aspects. And there was another question from Bruno also for Carolina, I do remember. And Bruno, would you like to ask your questions, or do you want me to read it?
Thank you, Giuseppe. I mean, I can ask. Can I give priority to participants because I don't want to take everything. So my question is, we're very curious. We're part of the Child Friendly Justice Project. We're conducting research on visual assessment tools for a child who are suspected or accused of committing a crime. So I'm just curious if you, as part of your research, if you come across any concrete tools for individual assessment. That'd be useful.
Thanks so much for the question, Bruno. Yeah, I mean, as I said, we're a bit mindful of like overall like recommending tools, concrete tools, because I think it's just, yeah, especially when it comes to checklists or methodologies, it can, you know, turn against the purpose, so to say. And, you know, if the approach would remain, or the mindset of the people, which, yeah, I think especially in the countries we worked with, we could see it's really a lot of work to be done, and like one single tool will not help it, you know. So that's why I think we're a bit careful about recommending tools. I can just think about one that was quite interesting, which is being used in the Netherlands. They have some kind of an app on the phone that the child can actually fill in for themselves. So they should kind of rate themselves, how they're doing in relationships, how they're doing at school, how they're doing, I don't know, in different areas of their life, quite a detailed app. And it's kind of a self-assessment by the child that is done by the child, then by the social worker, and then they kind of talk about it, which I think overall is quite an interesting way of doing it. Also, I think using the phone and the app is kind of getting closer to the child as well. So that may be one tool. Again, like not thinking that, you know, implementing the tool will solve everything, but it could be potentially interesting to look at.
Thank you, Carolina. There was Pippo Costello asking before for the possibility of a question. Pippo, do you want to ask a specific question?
Yeah, thank you, Giuseppe. Thanks to the panelists and thanks for the conference. I think it's a very timely method to discuss these things. My question is a note, probably the following panelists, and tomorrow we will address the issue. But I was wondering, listening to the presentations, we were talking about victims or person accused or suspected of crime. There are some, and we are referring to them as vulnerable person. I was wondering, Alessia is not anymore here, but if there are some works in terms of indicators that can identify what are the conditions that make that person vulnerable. Like when we are talking about trafficking or even getting in touch with the penal justice system, we see that there are some basic situations that are making the child vulnerable to be victims or even authors. So I was wondering if there is any reflection on that. In a lot of instances, the context and the causes that make children vulnerable, which are pertaining to the access of civil justice, are not properly addressed. And we risk to talk about trafficking, for example, without considering what are the conditions who are making Nigerian girls, for example, vulnerable in the system, not just because they are victims of trafficking, but they are part of a system that are not taking care of preventing situation of vulnerability. So I think it's a big question. It's probably very much at the core of the issue from what I can see. But I was wondering if the panelists have something more to say, how to prevent the vulnerability that the system itself is determining on children. And I'm referring, of course, particularly to unaccompanied children, but I think it can be extended to other categories as well.
Thank you. I think Alessia has already gone, so I do thank you people for your question. Is actually a big question, and I think one conference is not enough to provide the right answer. But let me add a comment to your question, telling also that the important development of the Italian system in terms of referral for victims of trafficking. We have seen during these years that as in parallel with the entire exploding situation of migrants, even the system is trying to cope, promoting also steps in the direction of a development. And what I can see is that, and Alessia was mentioning those things during her presentation, but we can think of indicators. You mentioned also indicators, people. And I think this is something that has been already done in the field of, in the referral system for victims of trafficking. And probably something like this needs to be also thought about judicial systems, especially when we talk about young children involved in proceedings. Definitely, it's something that's really touched the victim situation and the victim perspective. And I think it's time to move forward for the criminal justice system in order to establish ground rules for a referral system with all the actors that have to be in place, and also to define indicators to better address the vulnerabilities. I just want to give the floor to other two participants that asked the questions. One is from Maria Sole. Do you want to ask your question by yourself, or do you want me to read it? I can just read the questions. Well, Maria was asking.
Yes, thank you. Okay. You can read only my question. Yes.
All right. Maria was just asking if there have been made projects or research on children of incarcerated parents. Actually, this is not the topic of this this project, but definitely is an interesting question to look further in the future. And the other question was about well, if the research of Carolina have come across concrete and practical individual assessment tools that promote participation of children. Carolina, do you want to reply to the question? Thank you.
Thank you. I think I've already answered this question by Bruno, but I think there was another question by Stephen Allen, which is
Stephen,
which is is looking more at the practical part and looking at who should potentially coordinate effective multidisciplinary and individualized assessment, and to prevent children to be interviewed multiple times by multiple professionals. Yeah, I agree. This is a very important question. I must say we're not at a stage that we're kind of, recommending and good practices. We're still more just looking at what's actually not working in the countries we're looking at the moment. But I believe, depending on the national system, it would be good to have like a social worker, like one contact point, as you're suggesting here, that would really be the main contact point of the child, not to exactly expose them to multiple interrogations, which, for instance, now doesn't happen in the Czech Republic or Slovakia, but it's also not for the better, as they talk to one person, the child speaks to one person, but they're not properly involved. I think that the problem is more elsewhere. Just to add maybe on your question on the children of incarcerated parents, a very good resource is the UN Global Study on Children Deprived of Liberty. just to say it really covers a huge range of children deprived of liberty. So I think also the parents, the situation of the parents, so it may be a good research to look at. Yeah, and then maybe just for the question about the systemic deficiencies, that I think the answer really is also to just make sure that we really take this into account, that there's can be a child that really faces systemic discrimination in the environment because of their color of the skin, because of where they're born, because of poverty, and we take it into consideration and try to somehow compensate for that rather than use it on top of that as another problematic aspect of them. So I think there was one very powerful quote that we had from Mikiko Otani, who is the current chair of the UN Committee on the Rights of the Child, who came to our trainings, and she basically said, we really have to reflect on the fact that the children usually they behave based on how they were themselves treated by adults, by their parents, by their teachers, or by the society at large. So I just think it's really important that you're raising this, and yeah, it's really important that the professionals keep this in mind.
Thank you, Carolina. Well, we do have one hand that is up, who is Serena Romano. Do you want to ask your question? Elisa Bruno, sorry, I was mistaken. Elisa, do you want to ask your question?
Sì, buongiorno.
Yes, good morning. Good morning, everyone. I don't want to anticipate the content of my small speech, but I would like to answer the question asked by Mr. Costella concerning the prevention in the country of origin, and with particular reference to Nigeria concerning vulnerable victims, concerning children, concerning the age assessment and the multidisciplinarity mentioned by Carolina. Concerning the first question, I don't want to have the particular tones, but this path of prevention, taking into account the psychological aspect, vulnerability of victims, this aspect has been taken into account in Nigeria. Many years and many policies will be necessary, many interventions will be required. But just to give you an example, one of the biggest form of coercion of the victim is that of the voodoo rituals. That is to say, the victim is tied by the trafficker with voodoo rituals, as they are defined, and it is considered tied to this spirit forever, and the victim has to comply with the commitment to the trafficker. Let's consider that the spiritual condition of girls from Nigeria, and generally speaking, for girls from Guinea and Cote d'Ivoire, is very invasive. And concerning this, in 2018, in March 2018, Oba, the king of the spiritual community of Nigeria, issued an edict, and so girls now are freed from the slavery of this ritual. So the efficacy of this ritual is annihilated, and so the victims are free. We saw that this had very strong effects. On one side, it impacted on the consideration on the victim and on the fear to the voodoo ritual. and there was a change of strategies of traffickers. These strategies are now very dangerous. They use coercion, like retaliations and thrust to parents. And so this is the situation of vulnerability of the family is related to the vulnerability of the victim. Concerning multidisciplinarity of the individual assessment of the child victim of trafficking, the multidisciplinary approach is scientific too. In Italy, our judicial system has envisaged a precise protocol in order to check the age of the child with a high margin of error. But it is important to consider the age, the minor age of the victims, of the vulnerable victims in case of doubt. In the past, we considered the age only on the basis of the physical consideration of elements, for example, the development of teeth or the development of the body. Now we realize that thanks to anthropological studies and scientific studies, that even the puberal development and the development of the body of the person must be considered with the parameters of, with the ethnic parameters, not with the stereotypized or standardized parameters, without excluding the psychophysical condition, stressing that in case of doubts on the minor age or adult age, so the victim must be considered a minor with all the measures of guarantee in this case.
Thank you, Elisa. Thank you very much. Well, I think it's time for a little break, just 15 minutes, and we will come back. Just time to have a coffee. We see you later.
20 to 12? Shall we do it?
Yes, 20 to 12.
Okay, great. So I see you in a while.
I see you in a while.
Part to just type on the icon in the bottom of the Zoom application that says interpretation, and you can switch the language. And please, for whoever wants to ask question again, also at the end of this session we'll have a Q&A moment. Also feel free to raise up your hand to ask for a question, or feel free to write it in the chat, and then we'll bring it up to the conversation. Also for just to inform you, we would like to let you know that the conference has been recorded, and as far as you registered, you should have given your consent to the registration of the conference. So we hope that this doesn't bother any participants. And for the next panelists, but even including me, we would like to kindly ask, in case to use the earphones, just to have a better audio, if possible, and to try to speak slow. Well, it's hard for Italians, especially for Italians, because we used to speak really quickly, but just to make even more fluent and perfectly on time the translation, let's try to do this effort to speak not so quickly. And here we go for the session 2. This session is going to be dedicated to the sharing of the promising practices that have been identified in Italy regarding the protection of children in migration upon the criminal justice systems. We'll have the opportunity, we'll have the great opportunity to hear the experiences and the expertise of 3 different figures that actually are going to represent 3 successful way of operating as far as concern legal assistance, as far as concern social assistance, and going into the detail of the intervention, I would like to give the floor to the first panelist that actually was already kind of shortly introduced herself in the Q&A session, kindly answering to one of the questions that were posed. To Elisa Bruno, that is a lawyer from the Ordinary at the Juvenile Court of Catania, but even voluntary guardian, and that is actually is going to intervene on a presentation that is named Criminal Protection of Unaccompanied Children Victims of Crime, the Multi-Agency Approach in Catania. This intervention is actually going to be also linked to what was already shared before by the International Organization for Migration, as the Catania model is actually a really good and successful example of the a multi-agency approach that was actually producing good results. And Alessia as IOM, but even Elisa as lawyer and as human rights lawyer and as a voluntary guardian was really were really together also with other actors making a really excellent job that we would like to share with our international audience. So I'll give the floor to Elisa Bruno. Thank you.
Buongiorno a tutti, di nuovo sono Elisa Bruno.
Good morning, everybody. My name is Elisa Bruno. I am a lawyer specializing in juvenile offenders. I'm very happy to give you to talk about my experience, and I would also like to thank the previous speakers for having actually spurred so many thoughts about this topic. First of all, I would like to apologize in case my presentation or what I'm going to say is not really fully matched by my slides. Can you see my? No?
Ok, altrimenti possiamo inviarla noi, Sì, sì, per venire dalla regia.
No, we can see it now. Yes. I think we...
La vediamo. No, adesso non più. Aspetta. No, non si vede.
Aspetti, riproviamo. È probabile che ho sbagliato qualcosa io. Condivido.
C'è, la vediamo.
Yes, we can see it.
Benissimo. Non mi soffermerò
Okay, I
molto
won't
sulle definizioni
deal with the various definitions concerning trafficking in human beings, because this has already been mentioned by the previous speaker, by Alessia Cassia. What I would like to focus on is a preliminary definition that we have from the Council of Europe Convention on Action, THB, the Warsaw Convention 2005.
Se possibile mettere a schermo intero come abbiamo esattamente provato prima, sì?
Sì, ok, adesso?
Perfetto, grazie mille.
Ok, va, benissimo. Vi chiedo scusa, mi sentite bene? Sì.
Can you hear me? Yes, we can.
La Convenzione di Versailles.
So the Warsaw Convention, in practice, is the first real definition, provides the first organic definition of trafficking in human beings. It defines all those elements already mentioned by Alessia, highlighting the risk for exploitation, the transport, inclusion, transfer of a vulnerable subject to another country across a border by using coercion, abduction, in case of juvenile, children, also even without these coercive systems. Let's see here, just it's a sort of refresh. So we have the action. This is the coercion, the recruitment, use of coercion, and these are the aims of exploitation, forced labor or services, slavery or practices of similar to slavery, servitude, etc., or removal of organs. Before getting to the analysis of the individual entities in our legal system, I think we need to look at Article 11 of Directive 36 by the European Union, which requires member states to take all the necessary measures to establish appropriate mechanism aimed at the early identification or assistance and support for victims in cooperation with relevant support entities. This multidisciplinary approach is not just a practice required based on common sense, but it's required by the regulations that we have just mentioned, and failure to apply it is an infringement of the law. Who are the actors in this multidisciplinary approach? Who are the members of this great team to help children? First of all, NGOs, public authorities, immigration authorities, legal guardians, social workers, police, prosecutors and judges, and guardians, legal guardians, and health workers. On this very model, so to implement what Europe is asking us to implement in Catania back in 2016, as already mentioned by Alessia, after huge migration flows in those years, a multidisciplinary team was established of experts, including different professionals, that was named Catania City Counting Trafficking. This was established with the prosecutor's office in charge of trafficking crimes, and the juvenile court participated as well, police, non-governmental organizations, and the anti-trafficking authority, which has jurisdiction in our region, legal guardians, and the IOM. Now, all this aims at not only meeting applicable requirements, but in particular at protecting the victim, who has to be protected from all points of view. As already mentioned, under applicable regulations, 3 objectives must be identified in order to fight trafficking, in particular, repression, protection, and prevention. Based on data, on investigations on data, we realized that no single action can be implemented without all the other actions also being implemented. So protection of victim and subsequent emergence of risk of exploitation can be achieved only by, at the same time, implementing all the three pillars. We have seen that timely identification is essential because in this way it prevents any re-trafficking, abuse of traffickers, sexual abuse, complications caused by unwanted pregnancies, complications of other social complications. What are the indicators of possible trafficking of human beings? For sure, a difficult family situation, normally economic difficulties, age, lack of education, lack of information as to the journey they have taken, and also lack of information as to how to get to Europe. Europe is for these girls is a sort of dream to be achieved. I'm saying all this because this has an important impact on new forms of victim recruitment, abduction, forced marriage, other dependency on exploiters, a debt bondage, a debt was undertaken in order to leave for these girls. All these words and also false information received by these girls. What's the basic assistance that has to be guaranteed once a victim or potential victim is identified? For sure, a safe shelter, so reception, a fully safe place and shelter, urgent medical treatment, counseling and information as to the possibilities that the victim has for her life. Also, accurate translation and interpretation is important. And on this very point, unfortunately, I have to mention here that due to the lack of proper interpreting and translation, there is actually a confusion between cultural mediator and interpreter. These are two completely different professionals. So the interpreter just has to translate, to interpret what has been said to the victim's language, whereas the cultural mediator works in a different way. That is to say, also tries to interpret and to be a bridge between different cultures. These activities are very important, just like any legal advice and assistance is also so important. Now, as we were saying earlier, when answering the question that had been raised, when there is a potential risk or any doubt that the victim might be a child, might be underaged, so the victim shall be presumed, shall be deemed to be a child and shall be accorded special protection measures pending verification of their age. That's Article 10 of the COE Convention, Council of Europe Convention. Now, what is the most important thing that we need to do? What's the first action we need to take if we have established that the victim is a child? So as soon as an accompanied child is identified, we need to appoint a guardian. there are different protection strategies for children in Italy, in particular with reference to the protection of unaccompanied children. So appointing a guardian ensures that the child is granted all the rights, as mentioned earlier, all the rights required by the Convention on the Right of the Children, the CRC. We have seen that over the last 6 to 7 years, there have been several amendments or several changes in Italian legislation. In particular, a so-called Zampa law was enforced with a particular attention to unaccompanied foreign children, with particular reference to some more vulnerable conditions, for example, sexual exploitation, etc. I would like to tell you that as far as the children court in Catania, even before the enforcement of the Zampa law, that is to say, in which the guardian is a requirement, in our court in Catania, we were already providing all the necessary protection and assistance to children based on the provisions by Law 194, 1983. In other words, the Children Court in Catania would apply the principle of equality to all children in Italy. And the court would identify as vulnerable children who were unaccompanied without parents. So they could have been deemed to be in a condition of abandonment, so that they were left on their own. And this would ensure them all the necessary protection, a pro bono lawyer, for example, a guardian, and listening to the child, right to health care, and also to legal proceedings to be held and led by juvenile magistrates of the juvenile court. In this way, the child was actually protected from all types of risks. Then there is Article 18 of Legislative Decree 286, dated 1998. Alessia already mentioned the importance of emergence of trafficking practice. We can see here that already back in 1998, human trafficking is a very old crime. And I would say that that particular legislation was a very practical and also very detailed piece of legislation. All necessary resources and all necessary social policies were to be provided by taking a victim-centered approach and providing a comprehensive protection to victims. And the same applies to international protection. I'm not going into detail on this, but we all know that in particular trafficking, human trafficking, has been recognized also by NHCL guidelines, but also by practice and by court decisions, that trafficking is one of the elements on which political asylum can be granted. In particular, as to assistance to child victims within the Italian legislation, this assistance has to, first of all, ensure the best interest of the child in all actions and decisions. This can be achieved only by appointing a trained legal guardian, a properly trained legal guardian, and can only be reached through the respect of individual needs, and also in compliance with all the procedures required to assess the age of the child. As to well-trained legal guardians, I would like to point out two things. Zampa law actually has provided for voluntary legal guardians legal guardians who have to be close to where the child is. And actually, this is something new compared to what was done in the previous regulations. For example, previous regulations would refer to the appointment, let's say, of a mayor or people who are not close enough to the actual child involved in the case. So this is very important assistance provided to the child, this is so important that cannot be. I mean, the role of a guardian is so important that cannot be carried out by volunteers. Actually, I have the privilege of having developed and grown myself with children I was working with in the past. Again, guardians, as I said before, were only on a voluntary basis. So being a child guardian was seen as a sort of a charity action. But this has nothing to do with what are European regulations. According to European legislation, a child is an individual who is the holder of rights. And in order to guarantee them, these rights cannot be protected by a volunteer, let's say. So we need to have trained legal guardians. This is a basic requirement because the guardian has the responsibility to understand that the guardian's work has an important impact on the future of the child. So any voluntary work may actually jeopardize the future of a child. Now, let's see what are the various protection forms in the various criminal proceedings.
Punisce con pene molto alte il fenomeno della tratta. In questi tipi di procedimenti,
in these types of proceedings, It is fundamental, once again, the super specialization, competencies, coordination with the various actors who protect the child victim. And this is ensured during the investigation phase. Our experience is on the field, thanks to a constant and immediate work of relationship with the prosecutor's office. So the victim subject to threats was analyzed, and it was possible to follow the action to avoid the threat, sorry, and to develop a proceeding for the perpetrators. Child victims and, generally speaking, vulnerable subjects, in order to avoid various hearings with various actors, and this would be a risk of a secondary victimization concerning the past, the experiences and the trauma. So there is the evidentiary element. And so the child, the victim, witnesses in front of the judge, and it is a form of hearing that anticipates the debate and concludes the procedure of exposure of the victim to the proceedings. And so it is possible to acquire an evidence also for the debate, for the discussion, and for the final decision. And this allows to take some special measures of guarantee, for example, the use of a double screen room. The victim do not see the trafficker, the perpetrator of the crime. And the use of a filter, that is the preliminary inquiry judgment, who will filter the questions to be asked. And these questions, the victim will not have direct questions, and the possibility of recording, of observing the elements relevant to the psychological and the physical condition of the victim. These can be important indicators concerning the type, the existence of the crime. Once the trial has been launched, after the inquiry phase, the victim has the possibility of being civil party for civil damages, that can be applied to the perpetrators of the crime. Concerning this point, it is fundamental to ensure a connection between the guardian, the juvenile court, and the specialized defender, who can ensure the presence of the child within the trial. From a point of view of feelings, because I was damaged, so I have the right to participate, to listen, to contest, and to know what happens to what made me a slave in material terms, because this complaint can be already advanced within the criminal proceedings. I'm now referring to a clause, a specific clause with a double value, the no punishment of victims of THB as indicated by the Article 26 of the COE Convention. What does it require? In case of victims of trafficking, in case of crimes committed by them correlated to their condition of exploitation, so the existence of these crimes cannot be punished. And so the Italian system has not transposed yet in a direct manner this standard. But we can use the concept of a situation of necessity, of need, identified in the fact that victims were forced to commit those crimes because they were victims of coercion and of exploitation. I must say that there is a point of jurisprudence that is concerned. There are the crimes, the fact that the crimes might be correlated to false declarations, to false information about themselves and names and so on. But the element of the behavior cannot be excluded. It is true that the crime has been committed and the victim has given false information on himself or herself, but we have to stress, and we hope that the jurisprudence, the case law will develop this principle, that is to say that the elements linked to the motivations of that action by the victim cannot be represent a fault concerning the type of crime, because it was committed because the victim was forced due to the condition of exploitation. There is another important principle. The forms of protection, of assistance to the victim are not conditional on the victim's cooperation with the authorities, the judicial authorities. The protection must be guaranteed. Let me remind you what Lina Trovato, the director of this table, magistrate of Catania, said. The protection of the victim concerning the repression action can never be correlated or strictly anchored to the declarations of the victim. We cannot think that we have to protect a person who is vulnerable and fragile if we anchor the whole procedure to the declarations. We must use some resources, especially during the inquiry phase, that can allow us to reach immediate and efficient results. But first of all, we have to protect the victims against possible retaliations linked to the credibility itself too. So I'm sorry, Elisa.
We are already with the time over, so if you may wrap up, would be perfect. Grazie. Just, se è possibile avviarci verso le conclusioni. Grazie mille.
I have finished. Thank you. Sorry. Concerning the irrelevance of consent in case of children, we have already talked about it. So I have come to my conclusions, and I think the reflection has already been mentioned in the questions. So if you want to go faster, go by yourself, or otherwise, if you want to go far, you go with others. So when can we consider the path of risk of exploitation concluded, and how does child justice system affects prevention and child victim protection? The last consideration, I always remember the sentence of one of the girls I was guardian for. So she was called a victim, and she said, I don't want to be a victim anymore. I want to be free. This path is concluded when the autonomy is ensured, and so the protection of the vulnerable person must be ensured also through a courageous investment in terms of social and policies in order to avoid that the victim can be involved in other exploitation forms. Thank you. Thank you.
It was really nice to hear you. So now we proceed to the next intervention. It's time for the Miss Carmela Polizzi and Francesca Paola Di Maria of the Social Service of Palermo, the USM office, to make an intervention about the USM experience with unaccompanied children upon juvenile criminal proceedings. In detail, just to introduce briefly the two speakers, the two voices that are going to bring up the USM experience, we would like to introduce Miss Carmela Polizzi, who is a social worker from the Social Service Office for the Children of the Juvenile Court in Palermo. And both of them, Carmela Polizzi and Francesca Paola Di Maria. One of them is the coordinator of the project area, including even EU projects, while the other one is also the contact person for the area of social occupational inclusion. So please, the floor is yours.
Buongiorno a tutti.
Good morning, everyone. So, Francesca Paola Di Maria and Carmela Polizzi. We are officers of the social services of USM in Palermo. USM is a child service of the Department of the Juvenile Service Protection Service. It is a service present all over Italy with the professional autonomy in terms of competencies for juvenile court and the judicial authority, and the activities for children who belong to the district of the Court of Appeal. And this means that our service is concerned with the children in this province and in the similar provinces. We have the headquarters in Palermo. We also have offices in Trapani for the work on the territory. The activity of our service, USM, concerns children in the criminal circuit, and the age is starting from 14 years and until 25 years. A few years ago, it was until 21 years, but now it is until 25 years, in order to assure a continuity of treatment for children, for minors, in order to avoid difficulties that can concern the translation from juvenile facilities to adult facilities. So, adolescence is an age in which people are in development, and so crimes are committed in a moment of difficulty. There is a path of growth, and so the transition to the adult facilities might stigmatize the institutional activities of USM are linked to the ministerial circulars of 1996 and 2006, which define the operating modalities, the methodologies used, the tools, the document of our work. The document is the decree, is a special decree that redefines the juvenile justice and the activity of USM, underlying the specialization. So the Presidential Decree 448 places at the center of the activity of the interest this system. But anyway, all systems concerning the minor, the social context, the family, the lawyer, the social services, territorial services, magistrates, and so on. All these systems interacted, work together in order to define the interventions concerning minors and the activity in the context. This Presidential Decree 448 bases the activity and the philosophy on the central element of the minor and on the responsibilization paths that the minor should follow in order to repair the damages and to recover a relationship that was interrupted with the collectivity. This decree envisages that the punishment is proportional to the crime, but it has a function of rehabilitation, and it gives back to the collectivity a person who has followed a social rehabilitation path. And this decree also has a path of repair. It is not a recent concept. It modified a bit the sense of our intervention, because let's say that this also concerns adults. When a crime is committed, there is a social pact that has broken concerning the social coexistence. So in order to repair this crime, so we have to recover and to repair the conflict. For example, in the projects for our minors, for our children, there is a special activity of repair to repair the damages following the crime by working for a community, by working free of charge for a community. So the juvenile criminal proceedings are based on some principles that control our work. All actors involved, so not only social workers, and there is the principle of suitability. All interventions must be adapted to the needs of development and of education of the children.
Diciamo, gli interventi sia della magistratura che degli operatori sociali devono essere finalizzati un po' ad una...
All action by the judges and by the social workers normally provide for some time for the minor within the criminal system. So obviously decisions may vary depending on the type of punishment which has to be given, depending on the type of crime, whether the child, the minor is a repeat offender, etc., etc. Another principle is to focus on education of the child. All actions related to the child must be based on their personal history, family situation, so that the entire education process or rehabilitation process has better chances of getting successful results. Now, I would like to give the floor to Ms. Carmela Polizzi, who will talk about, we can't, it's not very clear, actually. So the assessment is focal for all children who are involved in criminal actions, and in particular to unaccompanied foreign children. This is focal, this is key, because it aims at having it aims at having magistrates enforce measures that are suitable for that specific child. That is to say, that specific child with their resources and skills is actually able to support the entire criminal proceeding. This is very important, especially for foreign unaccompanied children who are even more vulnerable, who have a very unique life experiences that must be the subject of this individual assessment. This individual assessment is carried out by social workers. The social workers are sort of the director, the manager of the entire assessment, because to have meaningful assessment, it has to follow a multidisciplinary approach involving all services and all operators who are already taking care of the child or who need to be involved in order to provide an exhaustive individual assessment. This is another important point to be stressed. That is to say, individual assessment has to be based on a multidisciplinary approach. And in addition, it has to involve the guardian, the child's guardian, a cultural mediator, an interpreter if the child doesn't speak Italian well. and it has to involve all the elements and also all professionals who can provide an assessment about the various vulnerabilities of the child as well as their potentials, I would say. Potentials must also be examined and also capitalized upon. In addition, several background elements, if there is any support from the community, what the community is able to provide to the child. All these elements must be looked at, examined, and capitalized upon, leveraged, in other words, when trying to have an overall assessment. As I said before, strengths, resources for the child must also be included in this assessment. And at the same time, psychological support must be provided by social workers or by the host, for example, by the person hosting the child throughout the duration of the juvenile criminal proceedings. All this is very important, first of all, because the child has to be supported in general, but at the same time, the child must be properly informed about all the steps in the juvenile criminal proceedings. At the same time, the child must be aware of what's going on and what the child has to face within the child justice system. At the same time, the measures must be adequate for the child and can actually be borne by the child. At the same time, the criminal proceedings should not stop any education process that the child may be following. So assessment, individual assessment, as we said earlier, is important to develop and to build the right sentence, the right punishment. But at the same time, we must remember that juvenile criminal proceedings are not just looking at what happened at the crime, at the offense, or most importantly, the juvenile criminal proceedings have to take care of the development of the person. So juvenile criminal proceedings must be an opportunity for education. Hence, the entire process must be customized. In other words, it is very important to provide support to the child from social workers and also to control the child, not in police, not from a police point of view or law enforcement, but we need to have also flexible enforcement of the sentence, I would say, of the punishment. Interview is key in this because through the interview we can actually build a relationship based on trust. Trust is key here again, because based on trust we can actually get a better cooperation from the vulnerable child. We can actually assume that the child is under significant stress because of the particular situation they are experiencing. But all this is also very important to build a customized education project. capitalizing on resources, potentials of the child, and also in order to build some goals for the life of the child. So the construction of an educational project obviously takes care of already existing schooling and other educational process, as well as takes into account the possibility of involving the child into positive actions to prevent any repeat crimes by the child. After the assessment and while building the relationship with the child and through the entire action, if we can actually build this individual education project, all this is submitted to the judge for preliminary investigations, even before getting to the actual trial. In this way, we can actually suggest or propose to the judge some legal measures that will allow the child to implement this in this customized educational project. Actually, this tool is a legal tool provided for by the Code of Criminal Proceedings in Italy. We are quite proud of it because it's a totally new tool. Not all countries have it. That is to say, is the so-called suspended sentence. It's a criminal, I mean, this is provided, suspended sentence is provided for under the criminal code of proceedings. And by applying the suspended sentence based on probation and based on a project presented by social work, by social services, and based on a specific customized project, the magistrate suspends the sentence. Or any judgment is stopped to better assess the child and waiting for the end of probation, waiting for the outcome of this, the implementation of this project. Actually, at the end of the entire period, it will be up to the magistrate to totally declare the child as free. This is very important because the child is not punished. We have just a suspension of the sentence, and throughout probation and throughout several other activities that can be educational activities, schooling, training, restorative, an entire restorative approach, where the child is also supported by psychologists, by social workers, to help the child better integrate into the community. All this shows actually that criminal proceeding was just an accident, was just something that happened by chance, let's say, and the child may come out of it through successful rehabilitation. This is done during probation, during the probation period, and if probation is successful, the magistrate will actually cancel the crime totally, as if the child had never committed the crime. So obviously, in order to have all the process, to be successful in the process, the child has to be made aware and must have ownership over the entire the entire proceeding of the entire process. As we said earlier, this customized project is based on all the potential liabilities, resources the child has. The final end is to rehabilitate the child and to have the child integrated back into their community and to achieve a successful social and economic inclusion. You have 5 more minutes. What are the strengths and weaknesses in our system? The strength, for sure, the criminal trial for children, for unaccompanied foreign children who are followed by us because of crimes committed by them. This is a very specific procedure. Everything is totally unique and customized on the needs of the child. So we have a whole team of highly trained professionals, and this is a strength. That obviously another strength is the support and tutoring to the child throughout the criminal proceedings. Another important aspect, another strength is the involvement of the child throughout the criminal proceedings. Also, probation is very important. Probation has to be agreed upon by the child. And also, it's also an opportunity for education to the child. So this could actually, it is an opportunity for education. Then what about weaknesses? We can say that our youth justice system is a bit weak, at least at the beginning, especially for unaccompanied foreign children. When there is the report to the police, for example, within 72 hours, the child must be assessed for the preliminary investigation judge to issue, for example, an initial decision about whether their child has to be in prison, for example. This is a weak point because first, these are unaccompanied children, so they have no family, no relatives. Relatives cannot be involved. They are foreign. They are foreigners. So again, there are problems concerning the language, the understanding. But having passed this initial step and the children, for example, are sent to some closed facilities, for example, at this point, the system is highly flexible, so allows us to implement many different measures. Another weakness is a lack of sufficient awareness and a lack of proper training by social workers and by community workers in general. Very, very briefly, I would like to tell you about a case I followed in person. Ibrima, he is an unaccompanied foreign child. He committed a crime. He committed a crime within the community. a disturbance of order and quiet hours. Normally, the children we follow have committed only minor crimes. These children are vulnerable, are frightened. They're still very much distressed by their previous experiences, like, for example, this case, Brima in particular, he arrived to Italy when he was only 16, so he was angry at what had happened to him, and hence they claim for even minimal rights within the various facilities. And when these rights are not fully met, they become aggressive. They become aggressive with various operators. So it was not easy with him, because obviously there was the COVID pandemic, so we only had an online relation. He had experienced a previous trauma where his friend died during the voyage at sea. However, gradually, with patience, with a slow building and development of our relationship, and working in particular on trust building and on a relation based on a very customized report. Actually, we were able together to develop an individual educational project, which was also submitted in order to ask for suspended sentence and to start for his probation. It was actually a big challenge for him to continue school and also to pursue further education and training. Actually, after 5 months of probation, the outcome is certainly successful and positive. I still have a good rapport with Ibrahim. I'm still his reference person, because throughout the process we have implemented together and together with other operators working in network, we have actually worked together to support Ibrahim in pursuing further education. And he worked, he had an on-the-job training job in a restaurant, and after that he got a temporary job. Without that, he could have not renewed his stay permit. So he was able to renew his stay permit thanks to the participation of all various operators who together with me have supported Ibrahim. We are still working with him to help him ensure all the rights he is entitled to. That's it. I think I'm finished. Thank you, Carmela and Francesca, for your words.
Almost at the end of the session 2, we'll have the last intervention. We would like to actually be sorry for the little delay we have compared to the initial planification of the agenda. So if now it's time for Senera Romano for an intervention related to unaccompanied children and the criminal proceedings. She will bring up the experience of the Cledu. She's a lawyer from the Ordinary and Juvenile Court of Palermo, and she's also the co-founder of the Cledu Legal Clinic for Human Rights of the University of Palermo. So Serena, the floor is yours. Thank you.
Grazie, Antinea.
Thank you, Antilea. Thank you all for inviting Cledu to this important event. As concerned what has already said, it has nothing to do with the court, or if Cledu is a project of the University of Palermo, of the Department of Jurisprudence, in which lawyers, actors, operators, professionals, legal professionals work, doctors, students, and experts of immigration, who have as a common project 3 activities within the university: a front office in which we meet users, asylum seekers, foreign citizens, or operators of communities needing support in Piazza Bologna, within the Department of Law, and training, education for students of law, of the law faculty. And all these students are included in the activities of the front office. In this manner, they can experience the practical side of law, and not only of what they study in the books, and the widespread of a culture of an alternative use of law in contact with the mechanisms of social justice, with the creation of a diffused culture concerning the criticism to bad practices in order to modify them. For example, there is the strategic litigation in order to create a network on the territory of synergies with other social and legal professionals concerned with our issues. In 2016, we received the request of legal assistance for foreign unaccompanied children who arrived, and therefore we had to meet this need in terms of legal assistance concerning different profiles for a series of themes and indications concerning users, children. And as to the issue, I will present, and I'm very happy to intervene after the speech of Usm, because I think that there are some pieces that are correlated. The protection of the foreign unaccompanied children. Foreign children have 2 different connotations. Children can be victim of crimes. We heard it in the first speeches, or they can be accused in criminal proceedings, so they can be the perpetrators of crime. I would like to talk about our experience during these years, the types of situations and the type of critical situations. But it is possible to have a possibility of critical intervention, of correction of the systems that do not work. Concerning foreign children that are victims and that are perpetrators of crime, so we have recorded short number of cases in which children arrive at the trial as an offender. There has been an assessment of the crime committed. I'm not referring to processes managed by investigations facilities such as crimes of trafficking. I'm talking about common crimes to the heritage to people. So it is not often that the story of a child emerges in terms of victim of a crime. The story emerges. The story that emerges is casual. There are actors involved in children care, such as Save the Children. So they accept the presence and the hypothesis of a crime of children. And so they are referred to judicial authorities. These data are significant because it is the expression of an invisibility dimension of the children in the reception facilities, because the actors should monitor the exercise of the rights. So we observe some cases of proceedings for work exploitation. We are concerned with the proceeding in which children of a community were used to work in fields close to the community, and the managers were aware of this, and there is a proceeding in progress, and we have seen this from the examination. So they were used to work in agricultural fields, so in fields of the community or of the families, or within a pizzeria, in restaurants. Just to give you the idea of this situation, many hours of work per day, remunerated with biscuits, good suggestions, the work in restaurants and in pizzeria, 10 or 12 hours per day, 50 euros per week. What does this say? There is an important problem that comes from the absence of links on the territory. They are not aware of their rights. I remember that one of these boys that said, when I asked, why do you work for 50 euros per week? He said, it's a lot of money for me. So he had just arrived in Italy, and so for him, 50 euros per week was a lot. So there is a lack of monitoring of what happens within communities. Projects are renewed without the right attention to the real functioning of the facilities. There is the fear of the child to worsen the condition, and there is a situation of dependency on the perpetrators of the crime. It's a relationship linked to the fear to worsen the situation, because they don't know where to go if they lose their place. And there is the absence or lack of experience of the actors who should protect. We also observed other situation. We we also saw this crime of mistreatment, and not the physical mistreatment, but we are referring to a situation of degradation of a community in which the child lives, absence of a fridge, of hot water, of rotten food, unavailability of water, because there are children who say they have to go and fetch the water to fountains, heating, absence of heating, so they had not suitable clothes. So a set of aspects and so it is clear that all these situations can integrate the crime of mistreatment, From another point of view of the child perpetrator of the crime, so the cases of crime are similar to those already mentioned. We have children who are within communities and who are victims of violence and who commit violence also in terms and threats, private violence committed towards professionals of the community. It happened that we saw this. We experienced that these experiences, for example, a child who closes the door of the professional saying, you don't leave this room if you don't give me the pocket money. So these are crimes like extortion. And so in a context that has to be clarified because the exercise of the criminal action. And then the classical case of false declarations concerning the personal identity and a few crimes against the people and the heritage assets, robberies, for example. What are the situations we had to work on? So we observed a series of critical elements in the intervention of the police within the community determines a report that does not take the point of view of the child into account. The point of view of the children is not collected through the witnesses of other subjects, other children or other people who can an indication. Interpreters are always absent, and so children do not understand what is happening. And the intervention of the police is a sudden intervention. And we have observed this absence of the information of the child concerning his or her rights. And the lawyer will then meet the lawyer, but they will have then the information at this point, the information of this criminal proceeding. There is a huge problem concerning the content of the deeds of the documents, and they are not translated, and in many other cases the notification is given in a community where the child is no longer present. And so the notification is given to the community. It is clear that all this clears a huge problem because the child does not know that there is a criminal proceeding, and very often in the case or when the place of residence of the child is not sure, it's not possible to meet the child, draw up a report for the judge. The fundamental action for the preliminary hearing that will determine the exercise of the criminal action and the possibility of intervention. Having said this, the situations we experienced, excluding a small percentage of situations in which the crime had been committed, and so it was necessary to activate the path. In most cases, we had three types of situations, and I'm referring to more than 90% of cases we managed for foreign unaccompanied children. The first situation is that the crime is the reaction to violation to the children within the community. So the child is actually a victim of a crime, of serious bad operations of the community. And so the trial is as a contestation of private violence. And so the child, for example, was forced to work somewhere and he or she had not been paid. And so he or she has this reaction. You have, I worked, so you have to pay. Another situation, for example, when there is when there is the situation in which, for example, a child buys a boiler because it is cold within the community, and because I need hot water, and so I buy a boiler for hot water. These personal assets are confiscated by the personnel of the community without giving suitable explication, and this triggers the reaction. The pocket money that is not given, even if the community has not the problems with the sums that are received.
Another typical situation is the one, another important case that happened to us of misappropriation, referred to a girl who's still without papers. So some of her relatives who were living in Europe sent her payment to her to the community, to the center, but the center didn't give the money to her. So all these cases, again, there was this, there was a very severe reaction by the girl, and for which the police was brought in. And again, this is another way where actually the all the misactions against the child can be reported to the police. So we had 5 policemen who stepped in against this young 17-year-old girl. And obviously this is an issue, a big issue. That is to say, it is with the help of what is said, what is reported by the child, it is fundamental to retrace, to reconstruct the whole event, what happened, and everything has to be reported to the magistrate. And in the best possible way, it is very important for the child, if the child is the victim of some infringement of the law, that has the opportunity to tell what happened. So we know that unfortunately, in many cases, the child is always thought to be an offender and has to apologize and repent, unfortunately. Then there was another case of children with psychiatric issues who had not been properly identified and detected within the various reception centers or the various houses where the child was hosted. There in some cases, children have difficulties in controlling their own reactions, or they are overreacting. Then there was another case that we handled, that is to say, that was a clear mistake in investigations. This referred to a case in which the child was even in detention. The mistake in the actually in the assessment of or in the investigations was caused by the fact that victims were shown the sort of rogue, all the pictures of likely suspects, of likely offenders, and victims actually were not able to recognize the right offenders. The pictures were only black and white pictures, and actually there was a sort of bias towards black people. For example, the victims would describe the likely offender because the offender was black with thick lips, for example, with protruding lips, or with glasses. And based on these simple descriptions, they would just point to the offender. But this was a clear misjudgment and mistake in investigations. So again, we would need correct investigation protocols in what we normally do within s.r.l to provide legal assistance to children is, first of all, to meet the child several times First of all, to make the child aware of what's happening to him or her, to make him aware, to make him actually understand what's going on, and to give the child the opportunity to say and to tell his story. So it's very important to have an active role. That is to say, all documents, all evidence has to be completed with the personal history of the child, to try and prevent practices that drive towards a sense of acceptance of the crime that has been committed. In addition, we think that we would need to work in certain areas, such as training of law enforcement operators, of interpreters, translators, cultural mediators, all the professionals that are involved in the criminal proceedings of child offenders. Another important point is to monitor the various centers where these children are living and hosted. Also, schools must be aware of all the rights of children, and last but not least, children must be aware that they are the subject of the entire criminal proceeding, and they are an active player, not just a passive subject. I have finished. Thank you. Thank you, Serene.
The contribution you actually highlighted in the daily activity of the CLEDU. We are really, it was a really inspiring intervention, and also just connecting again to the importance of being aware about points of strengths and weaknesses, or we can say even lights and shadows. I would like to briefly just ask to Miss Francesca Paola Di Maria to bring up really briefly, because it may be really interesting just to give you an idea about some different consequences about the impact that a child can have due to some not really properly conducted assessment procedure, especially at the beginning, before a trial phase even. So I would like to bring the attention to a specific case that Ms. Di Maria was following, that actually was bringing up a different perspective compared to the success, well, to the positive example of the story of the child that Ms. Polizzi was sharing with us. So please, if we can have a short testimony about the case of another guy that was followed by the Ombudsman service, would be great. Thank you.
Grazie Antinea. Grazie Antinea, mi sentite?
Sì.
Can you hear me? We cannot turn on the camera. I'm going to talk anyway. Yes, please, you have the floor. So we'll be speaking without video. Oh. Okay, the case I would like to report here is a very unique case. In part, it's very different from the one presented by my colleague. The boy is called Rum. He came to Italy back in 2015 on a boat after the usual incredible voyage, and after months where he had to stay in Libya, where he suffered a lot there. And when he finally arrived to Trapani in Italy, he was arrested because two boys who were with him, they said that he was the driver of the boat with illegal migrants. Although he was still underage, he was judged by a standard court for adults. He was imprisoned. He was sentenced to 4.5 years. He served 3.5 years. And since he had appealed, and in the Court of Appeal, the magistrate, in the light of the fact that the child was underage, he submitted the whole case to the child court. And in the meantime, he had become of age. Obviously came under very difficult conditions, coming out of prison. Actually, he said that he had stayed there in a center. He was helped by Doctors Without Frontiers and took care of him in order to provide him with food and clothes, but also to provide him with psychological support, because he had lots of symptoms of stress, trauma, stress disorder. And so we started to take care of him, aiming at the same objectives already mentioned by my colleague. As mentioned by Ms. Domano, Arum has never denied his responsibility as to was charged, because he had been charged. He did not plead guilty at all. They always denied. Actually, if he had pleaded guilty, the entire proceeding would have taken less time. Whereas since he pleaded not guilty all the time, that he was not the driver of the boat, this made no difference in what my service actually offered him. We carried out all the necessary assessments, personality assessments. We contacted other people who said they knew him. We contacted the police station to see if we could find a place where he could sleep, not to sleep on the street. So we started a very important individual project, and now he is part of common house where he's sleeping. He is now back to school and working in a farm. And actually, this rehabilitation process was one of the objectives we wanted to achieve with the boy. But on the other hand, under this project, he had to live with a woman, with a girl in a flat. But since he had meantime been involved in another project, with the on-the-job training and the money he got, he could actually become more independent. He did only 1 month of on-the-job training, and then we had the pandemic. The COVID pandemic struck. We had the lockdown, so he had many difficulties because of this. And we tried to help him, and also other charity institutions tried to help him with some money, and we were able to help him. He asked, there were some nationals who told him to go and live with them. And after that, as part of another project called the social marginalization, we invited him to come to Palermo to live in a proper community house. For the time being, he's working as a farmer for 1 year. So the situation is okay now. But when I started working with him in March 2018, he was psychologically distressed. So following all the work that we carried out with Arun, as already mentioned by my colleague before concerning another case, he had never pleaded guilty. So hence we were not able to put him on probation. We could not actually enforce a suspended sentence proceeding because he had never pleaded guilty. And there was the court expert who was appointed, but the new court expert did not carry out a second assessment. So the whole file, as I said before, since this offender was deemed to be underage, so the standard court magistrate said that it was not had no jurisdiction, that everything had to be turned to the child court. As a social worker, from both a professional but also human point of view, I wanted to continue helping him. We are almost on daily contact with him. And then when the whole, but now we don't know what's going to happen now, because in the meantime he has become of age. He has already served 2 years in prison, but we don't know what's going to happen with the new proceeding that have not started yet. I'm in contact with the lawyer who is following him, but the hearing has not been scheduled yet. Sorry, we have to close. I've given all the information I wanted to share with you. Thank you. Thank you. Sorry for interrupting you. Maybe we'll leave some time for some questions or explanations. Thank you for all the information that you have shared with us.
Just to close up, even the USMA representatives were, by the end of the intervention, were willing to share with the audience two main open reflection, two main open questions. One related to which are the consequences of for the children once they get out of the criminal circuit. And another one is related to which measures are actually provided by our system for those children who are foreigners and are unaccompanied. So just in case the questions also are linked to these open questions, that these were the inputs that we received, that the USMA wanted to bring up to your attention. So now I'll give the floor again for a really short Q&A moment, and then we will close up hopefully by 15 minutes. So really sorry for the short delay.
Yeah, thank you, Antonia. We are running a bit out of time, but let's Let's give ourselves 5 to 10 minutes more just to read a couple of questions. There's the first one that is from Bruno to Elisa and Carmela as well. It means the Catania example and the USSM work example. Bruno is asking, how is coordination and role distribution of responsibilities ensured in the multidisciplinary approach that you described? Is there a formal protocol in place? Who manages the participation of the many actors? Who wants to go first? Elisa, perhaps?
Sì, mi sentite?
Can you hear me?
Sure.
The coordination is guaranteed by the prosecutor's office, DDA, the coordinator of our team, who controls the situation, considering the observation and the activity of monitoring of the cases presented. So the prosecutor's office and the anti-mafia office having jurisdiction for these crimes with Dr. Dina Trovato. In Catania, we have no strict protocol with the good practices. We wish we would have. We wish we had one, but we follow some models of guidelines, of the guidelines of the UNHCR concerning referrals. We participated in a project of OSHA concerning how to fight trafficking, and this confirmed the schemes of the protocol schemes, and I can say this, I will share it with you, present in many territories, in many models of Italian cities that have acquired a similar experience after ours. So the strength was determined by the personal capabilities, and this allowed to reflect on the creation of schemes and the virtuous working behaviors to reach these results. I'm sorry that concerning the, let's say that Mr. Romano, Mrs. Romano, concerning Palermo, talked about the victims, the children victims, but probably there is a lack of activity of identification of the victims at the very beginning. And there is not an efficient practice of coordination concerning the protection of the victim. So if the tools are not developed, the victim will never be identified.
Thank you for your answer, Elisa. The same question is also for our colleagues from the USSM office, Ms. Carmela or Ms. Francesca. How is the coordination and role distribution among your multidisciplinary approach? Is there a formal protocol, and who manages the participation of the different actors involved?
There is no protocol, but in reality, concerning criminal proceedings with the children, when a child enters the criminal circuit, so the social services, USM, of the juvenile justice are concerned. So the social service coordinates the various teams, the network action, in order to integrate all the contributions that have to be formally presented by us in a formal report to the magistrates during the criminal trials in terms of the various hearings of the juvenile court. It is very simple and standardized. It is obvious that it is our service to have this coordination.
Thank you very much. There's another question from Stephen, and it's always a question for the USMA office. What happens, clearly the question is referring to the situation of the Article 28, the probation time. And the question is, what happens in the situation that a child fails to fulfill the requirements of an individualized educational measure, such as been described before? Will there be more severe forms of punishment? I'll leave you for the answer.
Concerning Article 28, so we have an education project. It is a sort of a contract between us, the child, and the judge, defined within a hearing. All the activities of the project must be complied with, carried out, otherwise the project will fail. But if the child, concerning certain activities in which he or she is not present, so if the project can be reviewed, remodulated, the child can be invited. Let's say that we have constant monitoring on the project in order to avoid big problems, in order to undermine the possibility of success. But quite often, the judge can call the child concerning the possibility of resuming the path. But if a path fails because the child abandons it or commits some crimes, and so the probation is suspended, and so the child can be subject to trials, the child can be condemned. It depends on the evaluations of the judge vis-a-vis the path of the child.
Thank you for your answer. Well, we have other two questions. I would like to ask a question to Serena Romano, and it's about the individual assessment. I mean, according to your experience, do you think that the individual assessment, considering young offenders, should start at the beginning of the proceeding, should start probably in an earlier stage? And do you think the police, it has to be part of this process of individual assessment or not?
Yes, we are not accustomed to that, but this is a principle envisaged. It is a general principle of the criminal proceeding that cannot be denied when we talk about children. The person accused of a crime must be informed and must be able to defend himself or herself. And so this must be placed within the framework of the foreign unaccompanied child. I talked before about this condition of invisibility of abuse that determines reactions and an accusation of crime. So I think that we should have the right glasses to look at what happened. And this passes through an individualization of the story, taking into account the point of view of the main character of this story.
Thank you very much, Serena, for your answer. There's the last question from Bruno, and I think it's a very interesting question because it's related to the time we're living right now, the COVID situation, the pandemic, and the fact that even judicial proceedings have been affected also by the pandemic. So Bruno was asking if do you feel that it was more it was for the USMA office, and the question is, do you feel it was more difficult to conduct an individual assessment and establish a relationship of trust with a child when conducting the interview online because of COVID-19? Definitely. The question is for Carmela and Francesca, but also for others if you want to reply during this time has been so tough for all of us.
Yes, when I talked about the story of Ibra, I said that the pandemic situation made things more difficult in terms of individual assessment because interviews were online during that period, and with a foreign unaccompanied child as compared to all minors who are teenagers, and they are not accustomed to this type of tool. They need a relationship, a face-to-face relationship where there are many aspects that are important to establish a relation. So this was more difficult, but online interviews organized with the guardian or with the professional of the center where the child was hosted. So all this facilitated things. And as USM, we used some simple tools, some simple narration tools by images and phrases that allowed us to have a series of elements that otherwise we couldn't have collected. During the lockdown period, our management gave us the SIM cards in order to keep working online with the children. So the children had our numbers. They could contact us immediately during the working time. So they could contact us in real time, and also on WhatsApp, a very important working tool. So this facilitated the creation of very, very important relationships. So yes, there was a difference, but anyhow, we found new tools and we used them.
Thank you very much for clarifying also this aspect. I see one hand that is raised, and it's Pippo Costella. Pippo, go ahead for your question.
Grazie, sì, grazie per questi ultimi interventi, anche perché vengono da un territorio dove...
Thank you for these last speeches, because we come from a territory in which the presence of foreign unaccompanied children is not proportional. So putting all the things together said by Mr. Romano, and then no, Mrs. Romano, sorry, Mrs. Polizzi and Mrs. Paola Di Maria. This situation, in this situation that is described, that these children who enter the criminal proceedings enter as the result of situations, structural situations that have nothing to do with them. Children who enter the criminal proceedings are the result of a system that doesn't work outside. I would like to understand their point of views. I'm referring to the colleagues of USSM. Yes, I must say, yes. Very often they are not entered into deviation paths. The system cannot be flexible. I cannot decode an unsuitable behavior that is punishable according to our penal code. For example, in the case of Ibra might have committed other crimes of this nature. He might have been reported other times. In the new center, without a constant mediation with the professionals. Thanks to the availability, my availability and the availability of other professionals to explain to him why a certain right was not immediately recognized and it was necessary to wait time and a series of procedures were necessary. The system is quite often not in the right conditions. This, for example, a serious crime of being boat drivers. In reality, there are no boat drivers. They are minors, children who are put in the front line as compared to the guilty people. So we should find a way to read things differently before formulating an investigation that is very serious for our unaccompanied children. We said in one of the two issues that so let's say that the definition of a crime for a child is linked to the fact that they are unaccompanied children, because they are hosted in centers, they stay in difficult situations, they don't know, they can't speak Italian, and so it's very common to pass to a situation of crime for them.
Thank you, Carmela. Thank you, Francesca. And thanks also to Pippo for the question. I think we can take the last question that is from Serena, and then we have to call the end for today. Serena, the floor is for you.
Sì, grazie. Sì, più che una domanda.
Thank you. It's not a question, it's a consideration concerning what Mrs. Di Maria and Polizzi have said. The clandestine immigration is a separate world, so it is important to create the departure situation. So even if the child is a boat driver, he or she is a victim of trafficking. because he or she was forced to drive the boat because he or she was exploited in a situation of vulnerability.
Quando il minore ha realmente guidato, cosa ci è capitata appunto di seguire e di affrontare, è fondamentale appunto la ricostruzione di una cornice che dia una chiave di lettura a quello che è successo. Poi ancora una volta
it's very important to reconstruct the whole actual circumstances. Many times actually these children have even never touched anything on the boat. They've never been the drivers of the boat. Never touched the rudder or whatever.
Thank you, Serena, for your observation. Well, Antinea, I give you back the floor and we can just try to complete for this day. Thank you very much for participating and for the interesting questions and answers that you have provided.
Thank you, Giuseppe. And yeah, we continue with this chain of giving thanks to participants, first of all, that have been attending the conference even longer than it was provided in the agenda. So we really also would like to thank again all the panelists that today have attended the conference, and even like we look forward. Well, even today there were some already some panelists that are going to introduce more details tomorrow. So we are glad that also some of the future panelists were already attending this morning session, and we would really like to thank every input that was given, but also the interpreters for the assistance they were providing during all the session. And we hope to, well, further than those participants, panelists, those people were, well, the technicians that were assisting for all the session that are going to assist us even tomorrow. We also would like to thank even some other partners, some other actors that have been collaborating, have been working with us, even in preparation of the conference, even in the definition of some contents that were treated during today. We as PRISM, we tried in the preparation of the conference also to involve some other organizations directly or indirectly, and we also would like to thank Save the Children that was not actually participating as a panelist, let's say, but we've been in touch in the preparation of the conference. Save the Children, especially for as a project as a project partner. If I'm not wrong, I'm not sure if it is the project coordinator of the Youthopia project that is actually addressing the issue more towards children involved in the justice system in the territory of Bari in Puglia, still south of Italy. And tomorrow we'll have the pleasure to continue also this kind of construction of bridges among different projects, as it was happening today also with the practice project and other projects that we're mentioning, but even as going to happen tomorrow with the CREW project, just to give you some anticipation. And see you tomorrow at 9:30. You can use the same link. We look forward. Have a nice day.